to our presentation from Disability Law Colorado. We're so happy to have you here tonight on behalf of everyone at the Autism Community Store. And we had so many people respond tonight that we have so many people waiting to get in. I'm just still trying to get everyone in. We do have Spanish interpretation room under the interpretation button at the bottom of your screen where there's all your toolbars. So we are recording tonight. This will be recorded and we will put out on our YouTube page as soon as we can. And we are just about ready to get started, I think. Let me just check with our interpreter Hilda and make sure everything is good on that end. And then I think we're about ready to get started because I don't have anyone else in the waiting room. Thank you for your patience. Okay. Okay, we're good. Thank you. All right, folks, we are ready to go. Emily, I'm gonna unmute you.
All right.
Should I unmute you and Sarah both?
Yeah, that'd be great.
And you guys can take it away.
All right. Well, thank you everybody for being here on this chilly Wednesday. I think it's Wednesday evening. We are going to go through some what we've titled hot topics in special education law. We're gonna I guess first, so I'm an attorney at Disability Law Colorado. I've been doing work in disability rights for about 9 years. And a lot of that has been in education. So like to talk about this stuff. Sarah, do you want to introduce yourself?
Sure. I'm Sarah Peelsticker. I'm also a staff attorney at Disability Law Colorado. I've been here about 2 years, primarily working on our youth advocacy team, doing a lot of education work.
Awesome. So we're going to try to make sure that we have time for questions, but please, if you have questions that come up throughout, feel free to ask them by raising your hand and we'll get you unmuted or putting them in the chat. Sarah and I will take turns presenting and the other one will monitor the chat box, the one who's not presenting, so that we can try to get to questions. So we're going to talk this evening about, first we're going to talk a little bit about Section 504 and the IDEA, the Individuals with Disabilities Education Act. These are two major federal laws that protect the rights of students with disabilities. So we want to kind of talk through some of the big differences there, and then talk a little bit about logistics of meetings, both Section 504 and individualized education program meetings. We're going to talk about modifying a plan for a student, and then we're going to shift our focus to talk about discipline and disability related behaviors. And we're going to end with a summary of dispute resolution options that are available when things are not going as they should for students who have disabilities. So the first topic we're going to cover is just a very broad overview of comparing this Section 504 of the Rehabilitation Act, which is an anti-discrimination civil rights statute, to the Individuals with Disabilities Education Act, which is another federal law, but it's not a civil rights statute, it's an entitlement statute. When students qualify under this, they're entitled to get additional services, and there's funding that comes along with that. So Section 504 covers any individual with a disability. It can cover parents, teachers, students, members of the public. It's very broad. The IDEA only covers students. So that's a big area of difference in these two laws. For eligibility for who is protected by these laws, Section 504 defines disability as a physical or mental impairment that substantially limits a major life activity. So it's a really broad definition of who's protected. We also talk about, Section 504 plans for students, but a student doesn't have to have a Section 504 plan in order to be protected by Section 504. So if there's a student who has a disability and they're being bullied because of their disability, they're going to be protected against that bullying, even though they don't have a 504 plan. The IDEA has 13 specific areas of eligibility. So there are 13 delineated categories, including autism, and a student must require special education, so specialized education services, in order to qualify under the IDEA. There are also some differences for initial evaluations. For Section 504, parental consent is required. Parents are not entitled to request independent educational evaluations, and they must be done within a reasonable amount of time. Under the IDEA, parental consent is also required, and it must be in writing. Parents are entitled to request an independent educational evaluation, and the initial evaluation has to happen within 60 days of consent. So the independent educational evaluation is something where once a school district does an evaluation, this requirement is available to parents if they disagree with the school district's evaluation, and it is done by someone outside the school district, but the school district pays for it. The school district can have some minimum qualifications around who can conduct the IEE, the independent educational evaluation, but they can't require that a parent use a specific provider. If the district doesn't want to pay for the IEE, then they would have to take a parent to due process to show why their evaluation was sufficient. So then a couple more things, looking at these differences between these two laws. Reevaluation, so looking again at data and information for the student. The IDEA requires that it's done every 3 years. Section 504 just says it needs to be done periodically, but generally 3 years, again, is what's considered that kind of periodic time period. Annual reviews are not required for Section 504 plans, but they should be reviewed as necessary. The IDEA does require that the programs, the IEPs, get reviewed every year, unless it's waived. There's a big misconception around IEPs expiring. They don't actually expire. Once you're beyond that 1 year period, the district is out of compliance for this review period, but they should still be implementing the last existing IEP until they get the new one created. So Section 504 plans, much like you don't have to have a plan to be protected, you also don't actually have to have a written plan to have a Section 504 plan. There could be verbal agreements that are related to accommodations for students that it's required once there's a Section 504, like an agreement on accommodation for a student with a disability, that becomes their 504 plan. It's best practice to put it in writing to make sure everyone's on the same page, but just because it's not written down doesn't mean it shouldn't be getting done. The IDEA does require that the individualized education program is reduced into writing, and there are very specific components that have to be part of that document. A few more things talking about the differences. Least restrictive environment is required by both laws, as is a free appropriate public accommodation. I see a question. I'm confused about what the IEP is in relation to these. So the IEP is the individualized education program. which is something that you're entitled to if you qualify under the Individuals with Disabilities Education Act, or the IDEA. So hopefully that clarifies that. So Sarah will talk more about discipline and manifestation determination reviews. But if a student has an IEP because they qualify under the IDEA, there are 2 questions that need to be asked about whether it was a manifestation of the student's disability and whether it was the result of not implementing that student's program. Under section 504, it's only the first question about if it was a manifestation of the disability that is clearly needing to be discussed. And a student who is disciplined is not entitled to a free appropriate public education if they're just qualified under section 504, but they are entitled to receive similar services as students without disabilities. So if a student who has a section 504 plan is expelled, they may not be entitled to receive educational services unless students without disabilities would be getting educational services. Under the IDEA, even if a student is disciplined because it's determined that the behavior was not a manifestation of the disability and not a failure to implement their plan, and say they're expelled, they're still entitled to some educational services so they can make progress on their goals. But it's not exactly the same as the FAPE standard when students are not removed from school like that. The dispute resolution options, Sarah's going to talk more about, so I'm not going to talk about that here. But then wanted to also point out some other things that often come up are bullying, which is categorized as harassment, and retaliation for advocating on behalf of a student's rights. These are both prohibited by section 504. There's no explicit protection in the IDEA, but if it's impacting a student's ability to receive a free appropriate public education, it could implicate an issue under that law as well. But the specific protections against bullying and retaliation come from section 504. And this will become, it'll become readily apparent why it matters to figure out which law we're talking about when Sarah's talking about the dispute resolution options, because different entities enforce these laws. So you have to figure out which law we're talking about in order to know where to file a complaint. All right, so looking at IEP, so section 504 and individualized education program team meetings and logistics. So section 504 requires a group of people who are knowledgeable about the child, the evaluation data, and the placement options. The IDEA has a very specific required list of people who need to be in individualized education program meetings. So it requires the parents of the child, at least one general education teacher, if the child is or may be participating in that classroom, at least one special education teacher, a district representative who can kind of commit the district to the things that are going to be agreed to, an individual who understands the evaluation results and can explain those. At the discretion of the parent or the district, other individuals have knowledge or expertise about the child. So this could be an occupational therapist, it could be an advocate, it could be other people who have knowledge and information about the child. And whenever appropriate, the child. So I see, is this slide for both 504 and IEP meetings? So section 504 is this blue box here for what it requires, and the kind of teal box is for the IDEA for IEP meetings. Kind of 504 have specialized transportation in it. So section 504 can include related services such as specialized transportation. So it would just depend on the individual needs of the child and whether that group of people knowledgeable about the child agrees that they need that to receive a free appropriate public education. Oftentimes we see specialized transportation in IEPs because that student qualifies under the IDEA for an IEP. But it's not impossible to put that in a section 504 plan if a student qualifies under section 504 and not the IDEA. Does this change if the school is public or charter? No, so public charter schools are the same as public schools. They're held to all of these same requirements. All right. So there is a component in the IDEA that explicitly requires meaningful parent participation. This is not explicitly laid out in section 504, but parents generally should be included as part of the group of knowledgeable people who are part of the section 504 team. But if we're talking about the IDEA and we're talking about an IEP meeting, there does have to be meaningful parent participation, and failure to do so can be a violation in and of itself. So districts need to consider the parent suggestions and, to the extent appropriate, incorporate them. The mandate to consider parent input does not mean to acquiesce, so they don't have to, the district doesn't have to do everything that a parent says they need to do without looking at alternatives. It does need to be more than the opportunity to speak, so that the district needs to show that it comes to the meeting with an open mind and is receptive and responsive to the parent's position at all stages. A parent's right to participate in decisions does not include the right to decide the specific school the child will attend. That's nuanced, but we don't have time to go into it tonight. Districts need to make substantial efforts to secure parent attendance at the IEP meeting. So this includes participation through alternative means like video conferencing or conference calls. And I see a question, what about time of day a meeting takes place? So districts need to make substantial efforts to have the meeting at a time when parents are available to participate, and that includes time of day. But there are some restrictions around teacher contracts and unions where they're not going to be able to have a meeting any time of the day or on weekends. So there are some limitations around kind of what's considered reasonable as far as timing, but they do have to make those efforts to figure out a time that works for the whole team, including the parent. Should the IEP team members be unable to reach a consensus after including meaningful parent participation, the district ultimately makes the decision and provides parents with prior written notice of their proposals and refusals. And a parent's way to challenge that is through the dispute resolution options that Sarah is going to talk about later. A couple other things. Parents with disabilities need to be accommodated to allow meaningful parent participation. And parents with limited English proficiency must also be provided access to meaningfully participate. So that could mean interpreters, translated documents, potentially recording meetings, if someone needs to listen to that later, or having someone like a note taker. Those are not all of the examples, they're just some that come up frequently. I'm going to go through these fairly quickly, just so we can make sure to get to everything. And I know we want to get through all the topics and have a little bit of time at the end for discussion if needed, but we have some tips to think about for trying to make sure we're looking at that parent participation and how we can improve it. So for parents, really planning and preparing for the meeting, what is or isn't working, ask for copies of any documents you don't have so you can look at them ahead of time. That way you can kind of review everything and come into the meeting with the same information as the school staff. Don't go it alone. If you're feeling like you're outnumbered or uncomfortable, you can look into getting an advocate or even having, a friend or someone else who can potentially come and help you so that you can later process all of the information. Sometimes these meetings can be pretty intense, and it can be helpful to have another person at the table with you. Find out who's coming to the meeting ahead of time. It should be in the notice of the meeting. It should tell you who's going to be there, and consider inviting others who have knowledge or expertise. This could be through including a private provider who, if they can't, attend the whole meeting, maybe they can write a letter supporting what they know about the student and recommendations, or maybe they can participate at a preset time by phone for 15 minutes of the meeting, trying to figure out how to pull in that other expertise that might be outside the walls of the school. Kind of touched on this, but you can reschedule meetings if the time doesn't work for you. Again, there are some parameters around that with teacher availability and whatnot, but you can reschedule if the time doesn't end up working out for you. Make sure you ask your questions. If someone's speaking in a way that you don't understand, ask them to restate it. Ask for evaluations to be explained. I know that those documents can be, 30+ pages of very technical information. And it's okay for you to ask for that to be explained to you. Effective communication and understanding are very important so that you, as a parent, can really participate and help be part of that team.
And Emily, there's a question, if you could tell us or tell them a little bit about how advocates work.
So I don't know that I'm the best person to answer that question. We are statewide, and we don't have just like education advocates in our office. So we refer out to other advocacy organizations a lot. What I can tell you is that advocates who are in this space can help navigate the process and can help, advocate for what it is that a parent is seeking. And if a student has developmental disabilities, there are local ARC chapters throughout the state of Colorado that you could start out with. And they have, yes, Peak Parent Center. Oh, Sarah's responding as me. Peak Parent Center is also a good place to contact. Oh no, that's Erica. Erica is also me. So, the ARC and Peak Parent Center, Parent to Parent, those are all good places to start. As far as meeting preparation, how far in advance should the school or district provide meeting materials? So, so they need to give you the information with enough time for you to have a chance to review it. So there's not like a set amount of time. You need to be getting the notice of meeting in time to be able to invite to have a reasonable amount of time to invite others to participate in the meeting. So as far as I know, and Sarah can jump in if she knows something more specific, but it's kind of a reasonableness standard in looking at getting those materials ahead of time. All right. Yeah, Sarah.
I don't have much to add. That's right. But I have seen, in dispute resolution options, like a family agreeing with the school about them providing in a certain amount of time in advance. You don't necessarily have to go to a dispute resolution process to get that result, but it is something you can ask for from the district. They might not legally have to comply, but you can always open that line of communication.
And I see that Kim Aguilar is from the Arc of Larimer, and she commented explaining kind of their process for advocacy. So thank you very much. All right, so remember, you are part of the team. You should feel free and comfortable sharing information and observations you've had and what you want to see in the plan. As we've talked about, they need to consider your input, but they're not always necessarily going to agree. And if ultimately there's a disagreement, that's when you go into the dispute resolution options. Keep the focus on the unique needs of your child. These are individualized programs and plans that need to be focused on what your child needs, not what other children are getting. If the meeting shifts to other things, try to get it back on track. This also shouldn't be a discussion about district resources. The law doesn't give districts an out for lack of resources. It really is based on what the child needs. Try not to counter disagreement with anger or take comments personally. I know this can be a very difficult thing. These are your children that we're talking about, but it is a long-term relationship, and it's important to try to preserve that relationship for that long-term benefit of your child. Sometimes people have to leave the meeting. Usually there's not a reason why you can't reschedule or ask for another meeting to complete the task. Can be good to have an agenda ahead of time so that you can make sure the important things are covered, whether that's an agenda that you and the school district come up with, or if you write down your own agenda for what topics you want to cover during the meeting and have that in front of you so that you can make sure you get to all of those things. And then after the IEP meeting, the document should be provided to you, and it's a really good idea to look through it and make sure that everything that you agreed on in the meeting is in the plan. One last quick section. Oh yeah, Sarah.
There's some more information about advocates in the chat, but there's also a question about staffing shortages, which says, if the district fails to properly implement the IEP due to staffing shortages, what threshold is the district held to? For example, SLP services haven't been offered all year, and in-person services are ideal given communication goals. Do parents have to settle for virtual or hybrid, or is the district entitled to provide in-person services?
So do you want to answer it, or do you want me to?
You can go ahead.
Okay. So it's all based on what the student needs and the IEP. So staff shortages are real, and districts need to think creatively about how to fulfill those services. So it's going to be different for every student. If a student can benefit from in-person or from virtual services, then perhaps that is the answer for that child. If a student cannot benefit from virtual services and can't make progress on their goals, and those minutes can't be fulfilled virtually, then the district needs to think about, contracting with a private provider or reimbursing the family to seek out those services. So the staff shortage issue is very, very real, but districts are still responsible for implementing IEPs. And to the extent that they don't do that, should be looking at compensatory services to make up for any loss that student suffered. Just because a student doesn't get services doesn't necessarily mean that they're going to fall into that category of requiring compensatory services, but it should at least be considered by the IEP or the 504 team. All right. This is a quick section. We're just going to talk a little bit about modifying a 504 plan or an IEP. And then I'm going to kick it to Sarah. So the must review category. IEPs must be reviewed annually, and it's best practice to review 504 plans annually as well. We've already talked about this a little bit. These plans don't expire per se. It's just an out of compliance issue with the district if they don't do it before the annual date. They also must review an IEP or a 504 plan before a significant change of placement. So if a student is going to in-person school and they're going to change to remote school, and we're going to say this is because the student's behavior is not because of the COVID pandemic, they would need to have a meeting before doing that, or they need to review the document. The should review category. You should review an IEP or a 504 plan after new information is received about the student. So maybe an outside evaluation, a new diagnosis. Those are things that should kind of trigger that we should review this plan situation. You should also review the IEP if there's a lack of expected progress towards annual goals. 504 plans don't have goals in them necessarily, but if the student has an IEP and they're not making that progress, that's a time when the document should be reviewed to look at why is that student not making progress and what can we do to ensure that they can. You may review upon reasonable request from the parent or school staff at any time throughout the school year. So you don't have to wait for the annual review period. If there's something that has happened and you want to review the plan, you can ask for that and they should consider whether or not it's appropriate. They're not going to have an IEP meeting every week. That's not going to be something that's reasonable, but if there's, a time in the middle of the year where you think that it would be helpful to look at the student's IEP, like they're being restrained, or having increased behaviors, those types of things, that would be a situation where a request could reasonably made to look at that IEP or 504 plan outside the annual review process. You can also modify a 504 plan or an IEP without a meeting, if the parents in the district both agree to the changes. Generally, these are going to be minor things that they would be looking at in the plan, not big major things. And the changes have to be in writing, if this is the case. So if there's no meeting, there still needs to be written information about the changes that were made to the plan through that mutual agreement. And with that, I'm going to turn it over to Sarah.
All right, so I'm going to talk about discipline and addressing disability-related behaviors. So first up, we're going to talk about manifestation determination reviews, or MDRs. What are they? When are they required? What do they look like? What to expect? So an MDR is triggered when there is a change of placement of 10 or more days, aggregate for related behavior, or 45 days if the conduct involved drugs, weapons, or serious bodily injury. So the way that the 10 days works, if a student is suspended for 10 or more days, then that would trigger an MDR. Or for example, if a student is suspended, for 1 or 2 days at the beginning of the year, and then a couple more days later in the year, if that adds up to 10, that would trigger an MDR. So an MDR should include the relevant members of the IEP or 504 team. And very importantly, at an MDR, only 2 questions are supposed to be discussed. Number 1, was the conduct caused by, or did it have a direct and substantial relationship to the student's disability? And was the conduct the direct result of the school district's failure to implement the IEP or 504 plan? As to the first question, the Office of Civil Rights, or OCR, who enforces.
Sorry, that's a typo. It's the second question.
Okay, sorry, the second question. The Office of Civil Rights enforces Section 504, and they've been silent as to whether the second question about the conduct relating to the school district's failure needs to be asked at an MDR. So this is not supposed to be a meeting about whether the student understands right and wrong. We see a lot in MDRs that school districts, says it wasn't related to the disability because the child clearly understood that this was wrong, but that's not really what we're looking at. Just because a child might understand it's wrong doesn't mean that it's not substantially related to your disability or the child's disability. So it's really important to keep everyone on track and really just focus on those 2 questions. Lastly, with an MDR, the school district must provide notice to parents to allow meaningful participation and give them opportunity to invite other relevant members, such as family or friends, advocates, etc. So after the MDR, if the behavior was a manifestation of the disability or a failure to implement the plan, so when looking at those 2 questions, if you answered yes to either of those questions, not both, but either one, then the student may not be disciplined. If the behavior was not a manifestation of the disability or a failure to implement the plan, so if the answer was no to both, then the student may be disciplined. If the student is disciplined and that student is on an IEP, they are still entitled to FAPE, depending on what, depending on what that punishment might be. And FAPE is free and appropriate public education. So if the student is on a 504 plan, they are not entitled to FAPE under 504, but as Emily described earlier, they still must receive similar services as students without disabilities facing the same disciplinary consequences. So if a student without a disability was punished in the same way and would still receive services, then a student with a disability would also need to receive those services. After an MDR, it's a good idea to have an IEP or a 504 meeting to discuss services, if there's anything that needs to change, what if the student has a different placement, what that might look like. And then you'll likely need to conduct a functional behavior assessment or an FBA and or review an existing behavior intervention plan BIP. And this says, do the families have to wait the 10 days to request an FBA? And Emily, I'll let you clarify, but I think that can technically be requested at any time without it, but it is triggered with an MDR.
Yeah, that's right. So the only time that the FBA, the functional behavior assessment, is legally required is after the 10-day removal that triggers the manifestation determination review. But we have seen situations where, you know, there's a lot of behaviors, there might be restraint seclusion being used, the student isn't necessarily getting, you know, suspended or, you know, being sent home from school, but there's just a lot of behaviors that might be happening that aren't getting to the 10-day trigger, where we would argue that FAPE, the free appropriate public education, is being impacted and the school should have been looking at an FBA sooner. So hopefully that answers the question.
You can go to the next one. Is the 10 days in a row or total? So it's total. So let's see. So 10 days aggregate. So as I said, if a student was suspended for 1 day or 2 days later, when that adds up to 10, that is what triggers the MDR. So functional behavior assessments and behavior intervention plans. So while required after finding that behavior was a manifestation, 504 and IEP teams also have discretion to conduct FBAs and review behavior plans at other times. So like Emily is saying, there's a lot of behaviors going on. That situation does pop up. You know, that you and the school district can look at an FBA or a behavior intervention plan at another time as well. The IDEA requires IEP teams to consider positive behavioral interventions and supports when a student has a disability whose behavior impedes his learning or that of others. So really focusing on what those positive behavior supports are as opposed, you know, to punishment. A failure to develop a behavior plan when a child needs one can result in denial of FAPE. And an FBA must be conducted by adequately trained individuals. Okay, dispute resolution options. And I will preface that there are a lot of them, and if anything gets confusing, just ask us to clarify. So on the local level, so we're kind of going to put it in 3 buckets. So the local level, the state level, and then also what the federal dispute resolution options are. So on a local level, the more informal options would just be sending a letter or an email requesting what you would like, or you know, requesting compensatory services, that sort of thing. We do recommend that as much as possible you do things in writing, so that if a more formal complaint option is pursued later on, then you would kind of have that paper trail. Another informal option, requesting a team meeting to talk about whatever the issue is, bringing an advocate or a friend to a meeting, and contacting the principal, superintendent, school board, or other leader if you are not getting your issue resolved. And then the more formal options at the local level, every school district has disability discrimination grievance procedures, and you can be in touch with your Section 504 coordinator about that if there has been an instance of disability discrimination. You can also contact the special education director in your district. All of those individuals for every district are listed on CDE's website, the Colorado Department of Education, and so you can go there to contact them.
And I was just going to add the Section 504 coordinator. Every district is required to have one. If you can't figure out who your district Section 504 coordinator is, you could ask your school principal or the special education director. And if they don't have one, that in and of itself is a violation of Section 504. Similar with the grievance procedures for disability discrimination under Section 504. it's required that they have those, and if they don't, that's a violation of section 504. So if you're trying to address something related to like bullying or retaliation, and you want to try to address it through the school district process, they should have section 504 grievance procedures that you could attempt to address those through. And then Sarah, we had a couple questions. Can you use a risk plan to make a decision in an IEP meeting after a modified student schedule from school to homebound due to behavior difficulties?
I'm not sure I'm following that
So
one.
I think, so essentially a change of placement, like from going to school to homebound, would need to be made by an IEP team. So an IEP team can consider a broad variety of sources. So if there's been like a risk assessment or a risk plan, the IEP team could consider that as part of deciding what the student needs and the student's placement, but it should not be the determining factor. It should not rule the IEP team's decision. It should not, they can't come to the IEP team meeting and say there's this risk plan and the risk plan rules and therefore the student has to be homebound. The IEP team needs to consider everything about that student and what they need to receive a free appropriate public education in deciding the appropriate placement and whether or not that's homebound. Is the 504 coordinator within the school or the district? So that depends on the district. Some of the district has to have one for the district, but sometimes in bigger school districts, there are section 504 building coordinators in the different schools. So it really does just depend on the district.
Okay, the dispute resolution options at the state level. So while these are all a little more formal, they do kind of go from least adversarial to most adversarial. Starting with the least, you can request an IEP facilitator from the Colorado Department of Education, and that just can be done on their website. And really what that does is bring a facilitator to the meeting. Maybe, you know, really the root of the issue is that you aren't communicating well with the school, and a facilitator might help kind of move things along. So if you, once you put in that request from CDE, the school district would have to agree to that, and then CDE would assign a facilitator to you. So for both facilitation and mediation, they sort of have a running list of people that they use, and then so they'll assign someone to you, and then you would work with them to sort of, you know, coordinate timing and all of that. So then you would have the facilitated IEP meeting and develop the IEP at that meeting. Then next is mediation. So that's also requested from CDE, and you can also do that on the website. And CDE is the Colorado Department of Education. So you can request mediation without filing a more formal complaint. Or when you file a more formal complaint, you can say you would be interested in mediation, but you don't have to do a more formal complaint in order to request mediation. So it's a similar process to IEP facilitation where if the school district also agrees to mediation, a mediator would be assigned, the mediation would occur. That would result in a formal settlement agreement, kind of to what you agreed to at mediation. There's also, you know, times when mediation falls through and you don't come to an agreement. And in that case, you might be pursuing a more formal complaint option at that time.
I was just gonna back us up a little bit and explain. So the state options that Sarah's talking about, these are for potential violations of the Individuals with Disabilities Act, Education Act, the IDEA that we've been talking about, or the state level similar law. So I just wanted to back up on that. And then for mediation, can you talk a little bit, Sarah, about like the expectations as far as like what parents might be giving up if they go to mediation, and like how, like what should parents know if they're going into mediation so that they're not like blindsided once they get there?
Yeah. So yeah, all of these state remedies do apply to IDEA. And then I'll talk a little bit more about what would be a remedy under section 504. But so mediation, I would say, I mean, it depends on if you're doing it as a result of a state complaint or if you are just requesting it. So one of the pros, I think, of mediation is that it does give you a little bit more control of the process. And I think, you know, if you're a naturally less adversarial person, mediation might be nice, because then you can kind of have more control over what the result might be. So, you know, we like to say you can kind of ask for the moon in mediation, and they may or may not give it to you, but at least they'll kind of come to the table with what they feel like they can offer, and you can determine if that, you know, would be enough to sort of resolve your concerns. You know, one of the big things in mediation is that any settlement you come to would be confidential. And that doesn't necessarily, you know, mean you can't, you know, talk within your family or to the relevant parties about it that would, you know, need to be involved in enforcing any sort of settlement, but it does mean that you can't, you know, go post about it on Facebook or something, and it does have that confidentiality requirement, so that is really important to keep in mind. And if you do it alongside a state complaint, if you don't come to a resolution, then the state complaint could just continue at that point. And I'll talk a little bit more about that when I talk about state complaints. And then if if mediation does result in a settlement agreement, then that's where the state complaint would end. But I'll come back to that kind of after describing what a state complaint is.
Sorry, I muted you on accident.
No worries.
I was just gonna say, you know, going back to what you said with the informal resolution options, mediation and IEP facilitation, which I think you've alluded to, you know, also give the parents and the school district staff more of an ability to maintain that relationship moving forward than perhaps a decision from a complaint might have. But there are lots of different pros and cons that if you're considering one of these options, it's a good idea to try to get more information by contacting our office or looking at some of the other resources available before you decide which one to go with.
Yeah, and it is really important to consider kind of your relationship with the school district at the time you're potentially thinking about these complaint options. Because I do think that sometimes with mediation, if you're sort of at the point where you've really tried to communicate with the district and that is not working, then maybe mediation wouldn't be the best option for you, because you would just be sitting at the table with a mediator with the same people that you've already tried to talk to. So that is just something to consider when looking at the options. So a formal state complaint filed with the Colorado Department of Education. So that would be for any violation under IDEA. And I'll talk a little bit more kind of about what would be a reason to file a state complaint, but just sort of the process. A state complaint would be filed with CDE. That form can also be found on their website. It's pretty parent friendly. You just kind of go through, fill out information, talk about the alleged violations, and then the school district would file a response, and you can reply to that response if you feel like you need to, but you don't have to. And then for not all complaints result in an investigation, but the way it's supposed to work is that if everything you alleged in your complaint is true, then and would result in a violation, then it would be open for investigation. So if it does get open for investigation, then the state complaints officer would conduct that investigation, and that might involve interviewing you, reviewing documents. They'll usually request a lot of documents from the district. They might interview different people involved, whether that's teachers, principals, administrators. And so they'll do the full investigation, and then they'll issue a decision from there, whether or not they find violations. And then if they have found violations, then they'll more than likely order a corrective action plan from the district, and other corrective actions that might be sort of individual remedies for your child. And so that could include things like compensatory services. The corrective action plan is usually kind of making sure a district's policies are in compliance, might involve training of different staff on kind of the issues that led to the complaint. And so those are just some of the remedies that you could expect from a state complaint. So lastly, the most adversarial would be due process, which is also filed with the Department of Education, and more information about that process is also found on their website. But so if you file due process, that's kind of the most like a court proceeding. So it results in a hearing before the administrative law judge. So whereas state complaint, the state complaints officer just sort of takes all the information and does their own investigation. Due process would result in a hearing where you need to present evidence, call witnesses, that sort of thing. And then after that, the administrative law judge would issue their decision. Okay, so a little bit more on all of those options and how they compare, just to sort of keep different things in mind if you are considering any dispute resolution options. So for both a facilitated IEP meeting and mediation, you as a parent guardian or the LEA, local education agency, so the school district, can request that. And then for the facilitated IEP meetings, you may recommend, depending on the circumstances. But for both of those, both parties have to agree to participate. For state complaints, any individual or organization can file those complaints. So in certain circumstances, we'll file those complaints, or we've worked with advocates who filed a complaint on someone's behalf. That can really be, that's a little bit more broad. And then due process complaints can either be filed by parent or guardian, or the local education agency, so the school district. So either party can file due process in a different scenario. So what issues are addressed under each process? Facilitated IEP meeting is usually disagreements about services under IDEA, or if there's complex issues for serving a student, if there's really just, the communication barrier between trying to finalize a few details, a facilitated IEP meeting might be your best option. Mediation, issues that can be addressed, dispute matters that are under the IDEA. So it can kind of really be anything. There aren't parameters, but it has to, fall under the IDEA. State complaints can also address any alleged IDEA violations, so failure to implement someone's IEP, or denying them the right to free and appropriate public education, and sort of anything beyond that. And so then a due process complaint, issues that can be addressed, the alleged IDEA violation involving identification, evaluation, placement, or FAPE. So we most commonly see due process being pursued for mostly those situations: identification, evaluation, or placement. So if you disagree with the school district, that can be your best option. So for example, a state complaint can't order whether or not you or where a child should be placed. A state complaint process can't do that. They might, order that you have a different meeting to talk about placement, but they can't say, based on these facts, this child needs to be placed at this school or in this classroom. But due process, you would be able to get that specific result. Statute of limitations, and that just sort of means like when you can't, or how long you have to pursue that issue under this process. Facilitated IEP meeting and mediation, there's no limitation. You can request that at any time. State complaints are only for things that occurred within the past year, and that's 1 year based on when the state complaints officer receives the complaint. So on the date that they receive the complaint, they will go back exactly 1 year from that day to look at anything that might have occurred within that year. And kind of on that, and I can't remember if this is in a later slide, so I'll just touch on it now, but state complaints do need to be mailed, certified mail, or dropped off in person. And so they don't count that by the date that you may have mailed it. It counts on the date that they receive it. And that's when the clock starts. Due process complaint, you can go back 2 years. So same idea. Cost, it's all free to parties, with the asterisks around due process complaints being that if you hire an attorney for that, then you would have to pay that attorney the fee that you would agree to them on. Okay, so who is a decision maker for each process? The facilitated IEP meeting, the IEP team meeting is still the decision maker. The facilitator doesn't make any decisions, they just help you to make those decisions. In mediation, the decision maker is also the involved parties. So once again, the mediator can't say, yes, this person wins, this person loses, that they're just there to help you come up with solutions. So it's still up to you on how that goes. In state complaints, the decision maker is CDE's complaint officer. So when they issue their formal decision, they kind of say, yes, this was a violation, or no, this wasn't. And in due process complaints, that is the administrative law judge. Timeline for each of these: a facilitated IEP meeting needs to occur within a timely manner upon request. Same with mediation, it usually occurs within 30 days to kind of make sure things get resolved and keep moving. State complaints, the decision will be issued 60 days after it's properly filed. So once again, that's the date that they receive the complaint. You'll have a decision within 60 days. Due process complaints, a resolution meeting must occur within 15 days to see if this can be resolved without going to a formal hearing, with the option to continue the resolution period for 30 days. If there is no resolution, then you have a hearing and a decision within 45 days, but that's only for expedited due process, correct? And so,
Sorry, I'm trying to find the Title VI stuff, so I was not listening.
due process, I mean, they don't, typical due process, you wouldn't get a hearing and decision within 45 days. That can go on for a couple of years.
So the 45 days for expedited for discipline is the total time. So this is kind of an additive timeline. So it's like 90 total, but it's 45 days. The hearing should be 45 days after there's no resolution, not after the date it's filed.
Got it. Is there room to appeal if you disagree with decisions made? So in a facilitated IEP meeting, there isn't an appeal process, but you could, move to a more formal process, such as filing a complaint if it doesn't go well. Mediation, same deal, where if it doesn't work out, you can file a complaint. But if you do come to an agreement and that agreement is violated, then you would seek enforcement in a state or federal court, sort of as a contract dispute. State complaints, they cannot be appealed, but either party can file due process based on the result of the complaint. Due process complaints, the appeal can be filed with a state or federal court within 90 days of a decision.
We have a question. Would you recommend that parents seek assistance if they believe they're at the point of needing to take one of these formal actions? If so, where? ARC, disability law, Colorado, etc.
Yeah, so I would definitely recommend kind of seeking out some advice before pursuing a complaint option, just because, as you can probably tell, there are so many different complaint options. And I think, we would be able to talk to people, a lot of people. The ARC is any advocate, attorneys can kind of walk you through what might be the best dispute resolution option for your issue. So a lot of times, we have seen parents who have come to us after they've already filed something, but we may have recommended something totally different. And so then we might not be able to jump in and help at that point. And so it is really better to kind of talk to someone before pursuing these options.
And we have another question, but why don't you go through these and then we'll go to other questions.
Okay, so lastly, the federal complaint or dispute resolution options. And so this is where section 504 really comes into play, because that is a federal law. Well, IDEA is too, but it's enforced at the state level. So you can file a complaint to the Office for Civil Rights under the U.S. Department of Education for any, if there's an issue under section 504. And so a lot of that would be discrimination, bullying or harassment, retaliation, those sorts of disputes. What's really important under a complaint with OCR is that it has to be filed within 180 days of the issue occurring. And so that's a super short timeline. And they do have some carved out exceptions, but they don't apply very often. And so it's really important to, if you think that whatever occurred might fall under a complaint to OCR, that you get that in within 180 days. Unlike the state complaint process, those complaints can just be emailed to OCR, and so it's a little bit easier to get things done more timely. A complaint with OCR, also like a state complaint, or I guess, like a state complaint, is a pretty parent-friendly process. You just need to sort of describe what's going on. And if they decide to open something for investigation, then they would be in charge of pursuing all the documentation, doing the full investigation, and all of that. There isn't a timeline on a decision with OCR as there is with the state complaint process. So they're supposed to be resolved in a timely manner. And sometimes they are, and sometimes they are not. And there isn't really a reason why some are and some are not. The other federal options are to do a complaint with the U.S. Department of Justice. So that would be, filed in a disability rights section or the educational opportunities section. And so that's really for, all of those more serious and more formal violations. Kind of like OCR, the Department of Justice doesn't really have a timeline. And so it could be quite a while before you ever would hear back from them about something. And then there's not really a timeline on when they might help do the investigation or come up with a resolution. Lastly is
sorry, just very quickly, and I know we're running over, but I just want to mention the Office for Civil Rights has an obligation to at least consider and respond to every complaint filed with their office. So you will get something from them at some point in time. The Department of Justice doesn't have that obligation. So you could file a complaint with the Department of Justice and never hear anything from them. So really the DOJ complaints are they pick and choose what they want to investigate. So it really is for big systemic things that might get their attention. Otherwise, you may or may not ever hear from them.
And lastly is just litigation in federal district court. So those are all the options. But yes, we do have until 7:15, so we still have time for questions, and I think that is where we're at now.
Yes, and we did have one more. Is there at least one more in the chat, and then we can see if there are others. Is there a specific amount of time that a school or district must adhere to when an IEP meeting is requested? For instance, the family wants 1 hour, but the school insists on 30 minutes.
I don't think there's a specified amount of time that they have to have, but they have to be able to talk about all of the issues. So if they need an hour, then they need an hour. Or if they need multiple meetings, they need multiple meetings. We have seen meetings that go really long and not all of the issues get covered. And so you would set a time to finish discussing everything. So really the threshold is, how long do you need to talk about everything? If they can get that done in 30 minutes, then power to them. But if they need the full hour, then they gotta take it.
And I think it's the only other thing would be like reasonableness. So like if there have already been 3 2-hour meetings, and now the parent wants another 1-hour meeting, and the district's like, I think we can do this in 30 minutes, like that's going to be a different scenario than if they're trying to cram an annual meeting into 30 minutes. So it's going to be, like Sarah said, there's not like a hard and fast rule. It's really going to be factually dependent on what's the time needed to talk about this in a meaningful way. And, you know, is this request reasonable? Lisa has a question for the advocates in the group. She looked up one of the ARCs and there are several listed. So I will put the ARC of Colorado's website in the chat, and they have links to all the chapters. So if
I think she's talking about.
picking a specific app, so I think you would contact their main line and they would sort that out. So I don't know that you would reach out to an individual person within there. They usually have some sort of process, and ARC advocates can correct me if I'm wrong.
And as far as cost, I believe ARC advocates are free, but there are some educational advocates that do charge, and they kind of have a more broad range of where they cover.
And just to clarify, the ARCs are not the thrift stores. They're related, but the locations for those thrift stores would not be the ones you would call
Yes,
for an
yes.
advocate.
Thank you. That helps clarify. Yes. So there are probably multiple ARC thrifts in Douglas County. There should only be one ARC advocacy. And the thrift stores help fund the advocacy services. But I put the link for the ARC of Colorado in the chat, and it has a page with with a map that shows you which ARC chapter is where. And if you're in a location that doesn't have a local chapter, the ARC of Colorado does have an advocate who they contract with to cover the areas of the state that don't have a local chapter. So no matter where you are, there are different requirements. Some of the ARCs require that a student have an intellectual developmental disability diagnosis in order to qualify for services, but some of the ARCs don't have that same narrow stipulation. So yes, and we're getting lots of good information about the ARCs in the chat. Thank you, Jesse, too. All right, any other questions? Or Sarah, other comments? We have about 5 minutes. Our office is Disability Law Colorado. I will put our website in the chat. And we're happy to provide the slides that we had tonight. We can send them to you all and you can distribute them to whoever registered. We're happy to do that.
We appreciate that.
We also have a lot of education related fact sheets on our website. So I will put a direct link to that. Our website's not the easiest to navigate. We're working on it. But we have a number of different handouts on different areas of the law, as well as the different complaint options, and a whole handout just on tips if you want to file your own complaint. So that link is now in the chat. And then, yes, the COPA, Council of Parent Advocates and Attorneys, has a directory for paid advocates and education attorneys, and that website is there too. So if you're in a position to pay for an advocate or an attorney, that's also a resource.
I don't know if this is helpful, but it's an anecdote about a state complaint that just happened with a family I know, and it did work for them, and it worked quickly, just like you said. So anecdotally, one family just recently did it that I know of, and they are being served through that complaint. So I know everyone has different cases, but it can work.
Yeah, and between Sarah and I think we've filed 10 to 12 state complaints in the last year, and we've gotten favorable resolutions in all of them. So it's, at least right now at this point in time, it seems to be working. I know through different times in history, the state complaint process, and depending on what state you're in, can lead to varying good and bad results. But at least right now, it seems to be like a good option for families who are having issues trying to get things sorted. Do you think it's necessary to get an advocate for a first-time IEP for a kindergartner? Also, do you have a time limit when they should have an IEP meeting? So I think that, getting an advocate, it just depends on the circumstances. Like, I can't say whether or not it's necessary. Like, if you want extra support, maybe you want to talk to an advocate before your meeting and see if you think it would be helpful. Time limit for when they should have an IEP meeting. So once they get consent for the evaluation, they have 60 days to do the evaluation and should be having an IEP meeting pretty much within that timeline. Talk about what types of things we do, multiple complaints themes. So our work is dictated by priorities that are set every fiscal year, which for us starts in October. For school-related work, our work this year is focused on disability-related behaviors and the things that come along with that related to the school to prison pipeline. So discipline, school push out, restraint and seclusion, educational services for kids who are systems involved, either in the welfare system, in placements in residential facilities, or in the Division of Youth Services. So that's kind of where our school work is focused this year, is on the school to prison pipeline type work. You said earlier that a district rep has to attend the IEP meeting. I've had 2 meetings, maybe not a district. So Lisa, we're not gonna be able to give you legal advice with applying the law to specific facts tonight. But I would suggest looking at the language on who's supposed to be there and the requirements around how IEP members can be waived and not waived. And if it's something you want to talk about offline a little bit more, you could contact one of us and we could talk through some of that. Sarah?
And I will also add that sometimes there are people at the IEP meeting that are designated as a district rep, even though that might not be how you know them. And so they might not say that, but technically they might be the person authorized as the district rep. And so that can get a little confusing. And so it might be worth clarifying with the IEP team.
Yeah, excellent point. Thank you.
All right, well, thank you guys. This
thank
is invaluable, and we so appreciate your time and just what you do and what you do outside of your legal work. You guys should, folks should Google Emily and Sarah. They're pretty cool people in general, it seems like. But thank you so much for being here, and we'll make sure that we post this and we will share out your slide deck. You can send that over to me for sure.
Perfect. Thank you. Yeah, thank you everyone for spending your evening with us. We appreciate it.
Yeah, thank you all.
Thank you.